So hello, Andrea. Hello, John. We're starting with the last day of the FLVS 2020, and this is the blockchain lab for blockchain governance and crypto law. And we are discussing the legal concepts, we're discussing the theories, sometimes we're discussing the time zones, sometimes we talk about why we sleep. So there's plenty of things that we can merge together into one workshop. And today, Vlad is going to be taking us into the depths of the crypto law because that is exactly what he wants to talk about and why it's not the legal system and why it's not the laws. So, Vlad, what is it?
Well, I actually have a more specific plan. Instead of talking about crypto law specifically, I want to talk about you know, what I consider to be like the hardest, most challenging, most difficult crypto law questions. But we can take a step back and talk about crypto law more generally. But I feel like we've already done this on some earlier days. And so let me say first what I'm hoping to talk about, and then and then we can field questions about crypto law. It'll come up. So basically, what I want to talk about is justice, sanctions, crime, and terrorism in crypto law. Um, sanctions, justice, crime, and terrorism. Um, these are kind of like the harder topics because of the nature of the law involved and of the way that crypto law is currently set up, basically, to obstruct justice, sanctions, obstruct criminal law and anti-terrorism law. Um, and so that makes it a very difficult conversation, and people don't. There's a denial left, right, and center, lack of willingness to face the issue left, right, and center. The idea that the issue is just being brought up for some nefarious agenda. All sorts of different reactions that people have when I try to bring this up. And so I think that this might be a great venue for this conversation. What do you guys think?
Here, here. Thanks, Vlad, for framing things so nicely. Interested to hear what you're going to lead us off with.
That sounds a very interesting direction to go. For me, the first thought comes up that if we go that direction and understand that there may be some kind of mechanism to hone things in, how to make this safe in a sense that it doesn't go overboard. I'm not sure who said it, but that was somewhere from the American right, where they basically said they call it the 1% solution, and then they had an attitude of like, look, if there's 1% chance that it's going to happen, we're going to do whatever we're going to prohibit people from whatever it is that it cannot happen. And then it kind of leads to this kind of excess in basically restricting people. So if we understand that there needs to be some kind of regulation, we also need to be sure that it doesn't boil over in that kind of. That's just my first thought, but I really like the direction.
No, that's a great observation, and like very much at the heart of some of the balance of powers issues that that come up when we talk about criminal law, when you talk about law of terrorism, when you talk about sanctions, when you talk about justice also, although maybe less on the justice conversation. So I was thinking we just take them one at a time and go through and just and see kind of what we think. And so I guess first, like, what am I supposing is part of crypto law? Might be a good conversation. Anya kind of prompted me into that, but maybe a good way to take it is like, let's first talk about sanctions and what we consider to be sanctions, and then that will kind of like show you the kind of like general frame of thinking that I'm taking when I'm asking this question, and then you can kind of respond and tell me why this is awkward or not the right use of language or whatever. So to me, the way that I think about sanctions is that they're basically a formal designation with a normative charge, and then possible follow-up measures. So there's like, like state sanctioned violence, which is, sanctioned by the state in the sense of allowed and protected. And then there's like sanctions against terrorist organizations, which are negative sanctions, and the state's supposed to provide measures to dissuade that kind of activity. And so sanctions are a really important kind of super general concept in law, and that has to do with the designation of some activity or some person, and given some kind of as something that's either supposed to be allowed or supposed to not be allowed. So it's like normative charge. And then some measures about, like what to do to protect it, what to do to dissuade them. So sanctions are this very general thing that, oh, we don't want this, we do want this. And like, this was bad behavior. Oh, needs to be protected behavior. And here are some measures for punishing, or here are some measures for protecting it. So sanctions is this really interesting, great word that can either mean like to kind of bless something with the law, or to like curse something with the law. And it's not even necessarily legal sanctions. There's also moral sanctions, and there's religious sanctions. There's many different kinds of sanctions, but they're all kind of normatively charged formal designations with some measures. That's kind of how I think about how I think about sanctions. And then in our case, in cryptocurrency, the specific kind of sanctions that we're interested in normally is sanctions against use of financial or property or money kind of infrastructure by people who are, for example, on a list that the Financial Action Task Force maintains. I think that's kind of like the most standard, basic example of the sanctions in crypto conversation that kind of comes up naturally and is kind of difficult. So to kind of use the sanctions language a bit, in crypto law, there's no sanctioned authority who has the like protected ability to censor transactions, or to revert them, or to do irregular state transitions or anything like that. It's in fact, there is not only no sanction, there's a specific sanction against it. And there are measures which aren't necessarily all formal, but they're just kind of natural outcome of people having serious beefs. So yeah, please.
So I'll bite your the hook, right?
Great, cool, please. I'm leaving some bait out here.
So here I'll talk for 1 minute and just propose some different things on the table that maybe pick up and maybe not. And I don't know how I feel towards these different things. When I think of sanctions, I think of allowed and not allowed, but also of incentive. Oftentimes it's juxtaposed against incentivization. So I think that that's a questionable juxtaposition.
Totally. And yeah, me too. I kind of don't exactly make that. I just say some measures, and those could be economic. Who knows?
Right. Yeah. So here's just a thought. So it'll be like 5 sentences. So the first is, oftentimes we talk about it as loud versus not allowed, and we juxtapose it against incentivization, but maybe, sanctions operate in a set of creative ways sometimes by people. It raises an issue of coercion versus non-coercion, but maybe coercion is not a value, but just a fact of life, and it takes different forms, and it's placed in different locations. It oftentimes is talked about as happening after something, and the question is about the level of specificity to allow for actors to know. But it can also happen in other ways. It oftentimes is a way of how we talk about what is described as natural. versus what is described as artificial. And so
actually unnatural, right?
Right. And so exactly. So like artificial, unnatural, political, versus and the way that we fill in those terms, spontaneous, order, natural, private, for example, that would be an idea that has arisen over the last 100 years primarily. That becomes like a way. So it's not just about just versus unjust, but it's a way we construct and practice how we want to think about those things. And it's also, I'm almost done. It's also sanctions. We oftentimes think of sanctions as government or some large hierarchical body versus, the other people or the plebs or some other group of actors. But oftentimes sanctions are also between different government institutions that have different institutional design built into them. So right now, an example in America, we think of the Supreme Court as a check on legislation. And we could think of that being a good or bad thing and how we want to maybe redesign. And so the conservatives for the last 30 years have been pushing for a very conservative court that can check progressive legislation, that would be, and put sanctions on it. There's people have the right to make claims. And finally, I think sanctions is also a way when we talk about things that aren't sanctions, when we talk about just people doing things to each other in the world out there, it's usually still sanctions. Maybe another way to talk about it in an informal sense is that those choices over the background institutional setup are what permit what type of behavior. So, for example, international.
Sorry, this is the first time I've wanted to interrupt because I disagree. Everything else has just been totally agreement. Because like there's no limits to that. You just need to like add a little qualifier there and say
totally
when it's within their capacity.
I'll give you an example. So like, and I'm not saying that these are like in and of themselves, So one way would be that it's hard. So two sentences. One is it's hard to think of a situation where we could find an actual Robinson Crusoe moment on that island where there's not actually already existing very complicated networks of rules and regulations that are allocating distribution of power and resources of which we are subjects of, or that we're even formed into.
And what's the explicit or implicit or necessary relationship between a rules-based order and sanctions?
I think I'm happy to, so I would put that on the table to hear what people have to say, because I think you've opened up a door to a really interesting big question. All I'm saying is that I think that maybe one way I would answer that is just
I'm just observing that you switched from talking about sanctions to talking about rules, and in a way that I completely lost your train of thought.
Sanctions in the way that private property is on one hand a set of rules, but it also lays out a set of liabilities, sanctions, permissible and unpermissible behavior,
sure.
Which is right. So
I just wouldn't agree that it's a set of rules. I would say it's a body of law, which includes things like rules and lots of other stuff.
Sure. I'm not going to be against that. I think like we could think about how we want to talk about that terminology and stuff. All I'm saying is that I think that what I guess my overall proposition is that how we, it's an aesthetic, political, cultural choice, how we decide to describe what is the natural and the unnatural, what's open to collective decision making and what's not, and stuff like that.
Yeah, and but do you believe in totally private sanctions? Like if I just privately to myself sanction your behavior as the best there is, and to be reinforced however possible, and is that something that you recognize as a sanction?
Well, can you shoot me in the face?
I don't think I ever could.
But I mean, we meet, and could you get access to a gun?
I mean, it might be legally possible in some settings, but
Right.
it'd be quite difficult in any setting.
I think you would find that there's the scope of what you could do and not do is heavily. It's like what's interesting
But I
is
don't
the
think sanctions and murder are comparable like that. I don't know.
doesn't have to be murder. Can you
Okay.
sue me?
Yeah, but that's a negative sanction. I was talking about a positive sanction.
Could you essentially force me to work a certain type of or set of jobs in a society?
No, but I might say congratulate you for your work and offer to pay you and for giving me grants and stuff. Like I could do that's like also positive sanctions.
And the extent to which your bargaining power or the power of your incentivization would have a pull on me would largely be due to what my bargaining power was, in part. I'm not saying it's also not personal. Like, it could also be, I think you're a fun guy that I would like to go just chill with.
Yeah,
I'm
I'm
not,
just thinking. I'm just thinking
yeah.
sanctions exist far outside of this kind of negotiation setting or this kind of adversarial setting.
So
You
that's my
know.
proposition back to you is it isn't, it just looks like it. It's sort of like the Wizard of Oz. But I'm not saying that, it's
Oh,
just
I don't agree. For me, that's
I
like
know.
the radical, hyper, like extreme violent legalistic perspective. No offense. It just kind of like assumes that like the only mode of conflict is adversarial, and
So
which I don't agree with as a
so
general
I'll
kind of.
so I'll just this is how I'll end my statement is that I really like family systems therapy, which is practice it, read it, stuff like that. And family systems therapy, which is a very soft sort of thing about listening and practicing behaviors and really understanding, is often all built upon the idea of becoming vigilantly aware of the way that we constantly make claims on each other. And I'm not saying that I don't want to use the word violence. I'm just saying that, I think that becoming aware of how coercion works and how claims work and how,
I wouldn't say claims are coercive. It's just law, just legal. We constantly use legal terms and legal argument, but it's a respectful, loving way. It's not like we would use it in like a coercive, abusive way. At least if you're brought up in like a loving environment and you have like love for the people you interact with and even fight with. Yeah, I don't think you have to have this kind of coercive posture at all when you're giving people legal arguments to get them to do the things that you need them to do for your like just interdependence.
not on the micro level, but just my feeling is a lot of the background, but I know, but it's interesting conversation, Vlad. I'm happy that you brought this up. Yeah, thank you. Really.
So to me,
But I really
well,
liked everything you said about sanctions. So until this one thing about this state sanctions or something, where I just thought. But anyways, thank you so much. Really appreciate it. I'm sorry, Fabian, for interrupting.
all good, all good. Yeah, no, I think it's a very interesting part about the positive legislative sanctions of like basically almost mandating conduct. And I'm maybe a bit more sensitive on that issue, but for me, any positive incentive, as long as it leaves the free will on the individual that you can comply with it or not, you basically have incentives. That to me seems fine. The moment that you can mandate any kind of conduct, I think that's a fairly dangerous direction to go, even if it's well intended initially. If it removes free will from the individual, maybe.
What you just described very much sounds as if we're basically talking about political incentives. So even thinking about economic sanctions that are being imposed between different countries because one country, I don't know, did not comply with human rights or whatever, and then a lot of different countries decide, oh, let's impose economic sanctions, and let's not take cargo from them.
Amazing example. And exactly the crypto law example. Imagine crypto is engaged in human rights abuses.
Mm-hmm.
But aren't there the sanctions that you limit conduct, not that you impose it, like that they're restrictive?
So like any sanction against is supposed to somehow be against that behavior, whether it's limiting it completely, stopping them from using the financial system, levying fines, seizing assets. Sorry to interrupt again, sorry.
So you want to basically kind of create an incentive for them to voluntarily do the right thing. To me, sounds different than basically forcing by violence or whatever means to comply with the particular
Of course.
conduct.
Well, I mean, there's just because sanctions are incredibly diverse doesn't mean that like I'm trying to say that I want like super low touch sanctions. Although I just want to explore without just like what like a scenario of what this might look like in crypto law specifically. What do you guys think? So let's say there is some kind of human rights violation, because this will help us bridge to the justice issue on the blockchain. Like let's say like a very large human trafficking operation running on Ethereum. Then you know how does crypto law respond to the sanctions against human trafficking and to the fact that the sanctioned activity is happening on Ethereum? Hypothetical situation, as far as I know.
So to me, the thing that came up already when you introduced it is that it seems we kind of lack this authority to sanction, and so therefore, you know, what kind of paths are viable? So, you know, basically, you don't want to suppress something that it just hasn't.
No, I mean, the sanctions are already there. I mean, the sanctions are there. I mean, this is clearly sanctioned against stuff. The question is just what can we do about it?
Oh, okay. So how do we apply it in a way?
Yeah, what could be the measures? You know, like what can we like cordon off this part of the blockchain and you know taint all the coins that come out? Like that seems like the minimum. You know, to add it to taint analysis. That seems like the minimum, right?
Exactly. I find that actually a very healthy approach when you basically have when you have a reactive approach where you can basically trace things back in the past and say like, okay, we basically need to flag this and therefore in a way disempower what already happened so that it's seems to be a healthy direction for me.
But is like you know that commitment to no privacy on chain that's required to do that taint analysis what we want? Like, do we want to have no privacy on chain so that we can do this taint analysis so that we can kind of see and therefore like censor when someone comes to us if we're you know with this kind of like revenue?
I think
basically essentially sanctioned cryptocurrency, you could imagine.
Yeah, I think it's not realistic if it's based on that for the simple problem. Like for example, through Central America, you have all kind of cash warehouses where they move in cash and then they phone a call and then they get the cash out in another country. And right, they could basically just create something that to evade these kind of troubles. So I see certain limitations.
Kind of, but usually they need partners to do that, and those partners end up not wanting or not being able to easily sell these tainted coins, and so it's not that simple. They won't get the full price, et cetera, et cetera.
Okay, yeah.
But I just wonder, do you guys have any other ideas for like you know measures? I mean, I'm sure there's lots.
Andrea, you're muted. Unmute. Or maybe you're not muted, but we can't hear you.
Muted on hardware rather than in the Zoom.
Oh, okay. So she's going to be switching. Anuj was suggesting something as well. Anuj, you can't unmute. So.
Oh yeah. I was just suggesting that when you, as an example, something that we used to talk about quite a bit few years ago, are like dark DAOs, as you mentioned, marketplaces and stuff, because it's not just that something, say, criminal or bad might be going on, but that if it's like if the actors are hiding behind the veil of decentralization, then the most you can do is maybe change the tokens because you cannot reach the people. But that's already something. But at the same time, so at least they will never have liquidity or movement of the coins, for example, because you cannot actually reach the people. So I think, yeah, I just mentioned as an example the fascination marketplace. That is
Yeah,
not that
those are
difficult to even
very
do actually, for
yeah.
example.
So and this general trend or idea that you can just engineer systems that are kind of harder to interfere with.
Yeah, exactly. And then, yeah, and the thing is, I mean, are we interested in, let's say, sanctioning what's happening on chain, as in the say tokens, like tainting the token, or are we? This is a very different question. If you say, are we sanctioning the actors behind it? Because in meat-based law, it is you could jump from one to the other more flexibly than say crypto because there's anonymity, though it's not much in Ethereum. You have trying to cash and stuff, but
Yeah, and
not enough.
people will sanction without knowing the identities or IDs or addresses too. Like they know some crime is
Yeah,
happened and there's sanctions. Just implicitly even.
yeah, and there could be a kind of devil's advocate to this, where they would say, "Oh, that's a slippery slope." It's like you don't want chain analysis on everything and who gets to sanction what, and that's of course a difficult conversation. Yeah, I mean, going back to maybe a step back, I think I I was thinking there is also a kind of I think we are thinking in terms of like we humans working on it or using the blockchain and how can we sanction some things. But there are kind of things in blockchain also. So you could even argue that the very act of producing a block, it's like the miner is able to be the legitimate one for that block to be the only one who can sanction this is the canonical block. And as per sanctions, there is enough incentives for everybody to go with that because that miner spend all the hash power or whatever. So if you don't go with that, you will be following the wrong chain, for example. So that's a kind of a way of thinking sanction in a kind of a pure crypto way, like something that doesn't really have a corollary to meat space
Yeah.
realities.
Although it feels more like a point where interventions are possible that
Exactly.
than a sanctions mechanism exactly. It's just like a more where somewhere where law can act to
Mhm.
intervene.
I feel like where I really want to defend blockchain and crypto sometimes in this sort of situation against a lot of colleagues who come at it with the state or and regulatory angle in that uh, one of the things that's so exciting to me about it is anonymity is that cash is anonymous. If I want to go pick up some pot, you grab money and you go find it and you make that transaction. Now we could talk about whether or not we would want it to be a public good or legalized or another thing, but
Or
there's a
corona safe mail-ins.
mate completely right. So in those sort of scenarios, and there's lots of stuff like that, and so there's something very important about having anonymous spaces that aren't and that aren't like places necessarily even for markets, but that we just want a lot of spaces that don't need to be routinized into to observation and put on chain necessarily. And that's where the interesting tension for me lies is on the one side, I want to preserve anonymity. I like the idea of cash as anonymous, and I love the idea of blockchain as anonymous. And I'm willing to take the fact that some people do bad things with it and want to think of other ways to go at that behavior without pushing the liability on the fiat currency issue or on the
Hmm.
blockchain
Yeah,
person. And on the
I
other, and I, yeah,
I hear you, but I I don't think your colleagues will. You know what I mean?
I may just add something. I think this is something that we all think is important, especially the people that are coming, from this space. But I'm sure you have heard about the MiCA and markets and crypto assets proposed regulation from European Commission and the Parliament that was issued, I think, like a month ago. And it very clearly, it says that things like that are not, possible anymore in the European Union. So like Monero and other stuff will not be regulated by this regulation proposal. And I think that this means that it doesn't, it's not in the scope of this proposal, and it might mean that it's not going to be legal in European Union. So it's not, I mean, we are not going to be able to use it.
I would say it like this: regulated financial institutions and intermediaries and crypto asset service providers and so forth won't be able to use it. And so, as a person in Europe, if you are, if you buy it of your own initiative, but you're not a bank or you're not a money service business, et cetera, you'll be able to use it. But if you're trying to interface with the financial system, then you have to comply with all this stuff. So I wouldn't say that it'll be unlawful or illegal, but it won't be regulated and therefore won't be allowed to be integrated with the system and use these institutions like the exchanges that are regulated there, for example.
But don't you think that if organizations and like businesses, whatever we call them, if they're not going to be compliant, they're not going to be able to offer us those services?
No, I just think they won't be regulated because there's no enforcement ability there, and so basically they just won't be regulated, and there will be public notice that they're of the fact that they're not regulated, But to actually have a ban, you need to have a way to enforce it, and that's not there yet. And so it's not there in the regulation. It's not there in practice. And so there's like a kind of, it seems like the strategy is, if you want to be integrated with the system, allowed on regulated exchanges, then you have to comply with all the stuff. And then the unregulated stuff is just, as you said, unregulated.
Yeah.
It's not criminalized.
It's not yet. Yeah.
It's not unlawful. It's not illegal, at this, and it doesn't seem like they have a credible path to making it illegal or yet. But if there's going to be like a terrorist attack, then or if there's going to be some serious crime, some high publicity crime, then or if for some reason the ethos changes, then they'll be able to criminalize it and make it illegal. But even post the sanctions, there's a gap there with the enforcement, which is very real and kind of is related to this whole conversation of crypto law and sanctions and justice and criminal law, terrorism.
I agree completely. The enforcement is going to be problematic, especially because we can regulate the things that are happening in the European Union, not outside of it. And this is,
and at the same time, you want to let Europeans buy and sell digital assets from outside, whether or not they're regulated EU crypto assets.
Yeah. But it's going to be very interesting because it's not final yet. So I think that they might think about things of better enforcement.
Yeah, but it's basically, there's only so much they can change, and they're like, unless they decide to, unless the whole thing doesn't get passed, that would be kind of the biggest change, I would say, that's possible.
Marina, Vlad, and any of our other colleagues that haven't spoken as well, Anuj, Andrea. I was such an interesting conversation. I really appreciate this. What do you think happens if the central banks move towards digital wallets and start moving that direction, and increasingly the cryptos are just turned into sort of investment assets or some, if there's a force, do you see that happening?
So let me put it this way. the European regulation that we just talked about interprets crypto assets broadly as investment assets, even when they're quote unquote stable coins or e-money tokens or asset reference tokens. Doesn't even matter if the assets that are referenced go down in price. They're all referred to as investments. And so they aren't really in tune with the tech realities. They're imagining it as an investment marketplace and treating it as such. And so as far as people act as if they're selling investments and are playing these roles that are identified in the regulation, they're going to fall into that kind of matrix, or they might have a risk of falling into that kind of matrix. And so, you know, I would say that just because the EU is regulating crypto assets as investments doesn't mean that crypto assets are investments. Doesn't mean that the crypto asset as a form, you know, isn't way more flexible and isn't going way more places than the regulation for selling investments has envisioned, you know, because like these tech forms are super primitive, and their taxonomies are already much more complex than is like commonly understood.
But I mean, just to add something here, this is like very interesting, because if we're looking from the point of view of law, if the law says, okay, those are, you know, investment, financial instruments, they are, you know, from the legal point.
Well, I mean, we can all pretend, you know.
Yeah,
but fine.
This part of the enforcement, you know, like, can you enforce something that would prevent the innovation that is happening out there from happening with this regulation or not?
Not out there outside of Europe, but out there in Europe, sure.
Yeah.
You know, in this case, or in the case of like you, the legal, what's the word? Let's say interpreter. Let's say the legal interpreter who's determining like what is what.
Yeah, the problem is that the people who are interpreting this are, you know, like 50 sitting in the European Parliament and European Commission. And there are some other people that are trying to fight that, and especially fight from DeFi. There are so many provisions out there that are limiting whatever is happening right now so much.
Yeah, but they're also, you know, not enforceable in international law or just EU law. And so it's not clearly material for crypto law itself directly, right? I mean, in Europe, sure, but like, is DeFi going to stay in Europe if you can't do maker in Europe?
I think it really depends on how this you know, regulation is going to impact other regulations and what's going to happen in US and Asia. I mean, Asia might be more flexible, but US is also trying.
Yeah, but
you know,
but if you think about right now, the kind of like context of different like nation states and in crypto law, there's momentum here, and it's going to take time for them all to converge, and it's going to take a long time for them to converge.
I think there is momentum here, and I think that we should be more active here. At least, you know, in Europe at the moment, the Europeans, and for the others, we'll see.
Well, I also think you need to consider that the kind of active political forces, they're not going to run out just, you know, whether one legislation is passed or not. So we also kind of need to expand the horizon of at least a decade, which in crypto space is probably more like a century.
That's a very good comment. I just the last thing, I'm sorry,
Sure.
But like, we have another 2 months in Europe to do that, because at the end of this year, German presidency of the European Council is going to end, and this is when they want to adopt this regulation at the end of this year. Yeah. I think for the next 3 years.
I hear you, and I've looked into it, and I'm trying to help, but also at the same time, no matter how little it changes, it is ineffectual, and so it's not a threat to crypto law or the crypto space. It's just the way it's written, it doesn't capture things. It doesn't it provides enough exemptions, you know. It doesn't do anything all that scary, in my opinion.
But do you think it doesn't do anything that scary because you don't think that the European Union as a market is important?
No.
Or
no.
the regulation?
just because their definition of crypto assets is like misses so much, just because there are so many exemptions for so many different ways that are so easy to engineer through, and also just because they're only really concerned about things that are kind of regulated financial institutions and regulated financial products, and basically like investment products. Like they, and you said earlier, like if they say it's an investment, then it is. I don't really exactly agree with that, because they can say, and we can pretend when we talk to them that it is, but that doesn't change the like underlying legal reality that it isn't. That is like actually going to drive.
What is the underlying legal reality?
It's an international law. It's in crypto law. It's not an EU law.
But how can you enforce that? The international,
I mean, a crypto law and international law are not enforced.
I know, but what does it help me if I'm a startup and I want to do something in the European Union? And
well, it's really easy to write the code and not be a crypto asset service provider, to not be an issuer, and to not fall into any of the roles outlined in the regulation. Really easy to operate without falling into any of those roles.
So Marina, I think to understand this fully, we kind of need to go back to an earlier point that Vlad made about this enforceability gap, and kind of look in more closely into that, because I'm certainly not against any kind of immediate efforts to optimize the situation locally, but this enforceability gap, which in my understanding, if I understand correctly, kind of leads to this branching of like you have the regulated world, and then you kind of have the Wild West, and we're kind of trying on one side to figure out how can we make that part safe where it's not affected by regulations. But then the challenge is, if the interface is where something is fully public, then you can basically you can basically structure coercion to over time kind of suppress that. So that's on that side. I see a lot of difficulty by sticking to purely public transactions. Anyway, that's my attitude to that. But I think that like how exactly that enforceability gap can basically be preserved if the regulated side starts to become more oppressive.
Yeah. But what I would love to explore, let's suppose that the EU is embraced by crypto law and international law, and let's suppose that we want to have all of the measures of like supervision, orderly wind down, AML, KYC, CTF, administrative control, these kinds of things, for any smart contract that is kind of marketed in Europe or has service providers in Europe. So let's just suppose, we could suppose more abstractly that there was eager willingness to comply with national criminal law on some criminal issue, or national financial regulation on some financial issue, or terrorist law on some terrorist issue, or let's suppose that there's this willingness and eager willingness on behalf of like everyone in Europe, everyone in Ethereum, everyone in kind of like the ecosystem who is like a person in like governance. That is not actually like a super duper simple legal situation at all, because there are many, many other national stakeholders that will be upset if they don't also have the same treatment. And so it quickly becomes an international law issue right away, even. Because if you try to say like make Maker an EU Maker, there's lots of people who aren't in the EU who are going to be like, wait a second. I'm not going to have this orderly wind down, administered, like supervised, like Maker that has all this risk, this EU risk that I don't need in my life. And they're going to put pressure on all of these people, and they're going to fork the code, and they're gonna have legitimate cases against complying with this regime. And those cases are going to be very likely much stronger than the EU's case, at least given the way this regulation looks.
Can you give an example, Vlad, of what you're thinking about how this regulation leaves these big ambiguities? Like, I know you're touching on that now, but like something that you have in mind concrete from the actual regulation.
So I mean, like, let's suppose that they decide that DAI is significant, is like a significant e-money token, then DAI would have to submit to orderly wind down requirements and supervision requirements. And so they would have the authority to mark them as significant and then order them to orderly wind down according to this regulation. And it's not ambiguous, it's just unenforceable and kind of it would be irresponsible for them to do that in particular because of all the international claims that are there, that all the non-EU law that's acting. It doesn't work to act in international law and to pretend that you're doing national law, or to do international law in global crypto law and to try to act like you're doing EU law just for EU people and people marketing to EU people. You know, it's kind of like imagine you think they're investments and you're doing EU law, but you're playing in an international law, crypto law setting.
In that situation, and I would defer to Andrea on this, I love it, like, this is cool. I could imagine creatively in the different dispute forums where that would go, that there would be, I can start thinking about ways that they would make cases that would be legal to do, that would defeat investor claims against them. But I agree with you that this is like the place to start thinking through this.
It's not so simple, because when you think about it internationally, you know, you're talking about like there's a major Chinese company that basically financed DAI from the start. It's like, who I'm not sure if DAI would exist without, and there's like enough investment internationally that there are claims, big ones, from non-EU investors. So even under the investment financial kind of law that they're trying to use here, they don't really have, they would have to compensate all these people at least, right, presumably.
So I think one of the big questions that is still out with any kind of crypto project, and I'm really not on the latest news of regulation, so maybe someone here knows better, but one of the questions is still even what is incorporation in crypto? So how or where would Maker be considered to be incorporated? What is the country of jurisdiction of Maker? Because if you can't establish that, then the whole investment protection system is completely derailed, because you can only have claims by corporations that are within a jurisdiction, and then you have to establish that there is a treaty between that jurisdiction and the other jurisdiction. So you would have to have an EU bilateral investment treaty with wherever MakerDAO would be considered to be, and similarly in trade law. So international law really operates so strongly with this idea that you have a nexus between the corporation and the territorial state. And so I think that for sure there are many creative ways of how you would establish that if you wanted. So you could say whatever the main computing power comes from here, or but I think that there is no
crypto law. Yeah, it's not crypto law.
No, not at all, not at all. That's why I'm saying that if you wanted to get at whatever kind of crypto investment vehicle, so if anyone wanted to rely on whatever kind of protection that comes from international law in the crypto space, the problem is that you first have to establish that you even have an incorporation somewhere, and that because of that incorporation, you can invoke this protection standard. So I don't know exactly how that operates. I mean, we talked about this in the DAO model law working group that Morshed mentioned. I'm not part of the incorporation question. So I don't know what they said.
I mean, I have a pretty clear like theory here. I think basically, you know, a smart contract, you know, isn't a national legal corporation, but there's going to be lots of people who, for example, like Maker has like development corporation in Europe. There's this investment fund that I mentioned that sponsored Maker from like before they launched is in China, and they have national forum there. And these, you know, their claim because of their investment in Maker, you know, they're going to have contracts with people in various jurisdictions, probably, right? They're probably going to have maybe a contract with this EU development company who built Maker. But the smart contract and these corporations that made this investment and built it and are the kind of like legal persons that are like part of this organization, you know, don't have complete administrative control of that smart contract at all. And that's kind of the interesting thing here, is that like the corporations involved don't have administrative control of all of the corporate forms involved, at least the corporations that are recognized in international law. Because there's these crypto law corporate form that is basically not incorporated in national law, that these national forms don't have administrative control on. At least in many cases. I'm not sure about Maker, how much control they have actually.
Yeah, so I think that, I mean, from a regulator's perspective, the move to make would be to come up with criteria that are easily detectable, and to say, okay, you know, I mean, everything in law is a fiction, so it doesn't really matter. It's good enough if you say, well, we want to get at, and you call it, we want to see where the major investment came from, and if the major investment came from this corporation that is incorporated here, then we will make a rule in international law that for crypto, for smart contracts, we locate them wherever the biggest investment came from, because this is what we can do. So I think that will be, in one way or another, a move like that would be coming from the regulators to just make it up in some way that is for them easily enforceable and doable. So that they will come up with something like that.
So that makes some sense from their point of view, and people might pretend to make them happy, but from the point of view of like many edge cases in crypto law, it's not going to matter, and their perspective will be ignored, you know. and so that's kind of the concern. You know, the concern is that like they'll pretend until they won't be able to anymore, because
I mean, so it will have consequences, Vlad, in the sense that whoever they think that they can put their finger on. So if there is in your example, there is a Chinese investment company, if that's the kind of thing that you can get to, if you can get to the physical assets, to the bank accounts, to the whatever of this company, then this is where they put the pressure. If that will ultimately succeed,
it won't succeed necessarily.
No, it won't succeed immediately directly, but it will put pressure on any kind of company that wants to make big time investments. So
you have to think about what will happen if it doesn't succeed also.
No, I mean, I think that the question of success or not success is difficult to answer. I mean, it's not straightforward, because of course you will say that the regulation has a particular goal.
So when it's absurd, it ends up being super straightforward, because it ends up being counterproductive and blows up in a way that is super duper counterproductive. So like, for example, this EU crypto asset market regulation, I think, is going to be counterproductive, and it's going to be very noticeable.
But counterproductive for whom? For whose interest?
For the EU, yeah. When something is absurd, it's like self-defeating. It's like for the EU Commission in this case, who's proposing this regulation.
I mean, I think that it depends, because I think probably the EU is walking a thin line, trying to, on the one hand, be an attractive investment place, trying to be a place in which you have a lot of freedom for startups and so on. And on the other hand, you don't want to be able, they don't want to allow for all sorts of risks to just occur. They want to know who is going to be liable and something goes south, whatever.
Yeah, so, but at the same time, they're creating like a Libra factory through these like asset reference token regulation, and they're way scarier than Mark Zuckerberg ever was, and they're creating this like then the reaction to like Libra and Tether and Maker is just like it isn't helping their whole like claimed goals, you know, of like financial stability,
But
et cetera, et
so I
cetera.
think this is where we are in the very interesting fix of what law is and how law works, because of course now we see in many ways. So on the one hand, you have this official regulation that puts forward some ideas that you may or may not find reasonable, but that they say are reasonable. And then you have on a very different level the question of what will the effects of these things actually be. And of course, the regulators are not stupid. Of course, they understand very well that there are all these levels on which these things work. So, and also they can predict what exactly is going to happen. They have maybe not, I mean, maybe they understand way too little about what they are doing. But then on the other hand, of course, you have people in the crypto side who are trying to bridge that gap and trying to talk to regulators in a way that is meaningful and to lobby. So you have all these levels on which somehow this regulation that the EU puts out then operates and goes in many, many different directions. And I'm completely with you that it can have completely opposing effects to what it claims to be doing. But that on the one hand doesn't necessarily mean that that wasn't intentional by the regulator. And number two, it doesn't mean that these effects that it will have just somehow disappear because they were counter to what was intended. They are still there, and then we take it from there and do things, start to work from there, you know?
I mean, of course, but what happens is, you know, is not pretty for international perspective, because like now you have like, you know, basically EU crypto assets being sold to everyone with like the full EU like commission report, like, you know, like a commission kind of supervision and rubber stamp, and you know, it doesn't seem like you can not have consequences for this. Let me put it this way. Even if everyone in the EU matrix pretends that this regulation is okay, people from outside are going to impose sanctions, have independent judgment, understand kind of that they don't have an international law posture, and kind of be super critical. It's you know, it's not like it answers this question of Maker's orderly wind down.
So I'm totally with you that it might have all these criticisms. I just think that the one thing that is most likely to happen is that the EU is going to be avoided in many ways, and there is a market that is lost in some ways, and for the EU it's a loss of investment that would be there and a loss of growth opportunity. So I don't know exactly what you mean when you say that it, from an international perspective, it will be troublesome, because I mean, who is that international? For whom is this troublesome?
Yeah,
because from the international perspective in and of itself, I mean, international law is nothing, has no soul. There's no
I don't agree at all. I mean, international law is like super real, and it doesn't need to be enforced to be real. And
definitely, I'm an international lawyer. This is my life. Of course, it's real. I agree.
But you just said there was nothing there.
No, but there is no one. So there is no sociological entity that is international law. There are nation states, and there are international legal officials, and all these things.
Law that is a person, right? Like no law is a person.
Yeah. So I'm asking whose interests are being violated, or whose interests are being violated like this. When you say international law is upset, then who do you have in mind when you say that?
So think about everyone who now has to act because of this regulation in order to protect their people from and to play this kind of crypto law game that they're playing.
So other national regulators.
Yeah, other national regulators now, many of them have an obligation to say what happens with EU crypto assets are being sold, and when people are doing crypto asset stuff locally, it creates international law obligations, because these assets are going to be sold, and Europeans who are regulated by this regulation are going to buy stuff from international sources. This trade is highly international. There's no way in which this isn't an international regulation. It's like not going to be, it's like, it's already international by virtue of being EU-wide. And then it's like more international by being about crypto assets. And so it's like, they're on contested turf internationally, pretending that they're just in Europe where they get to have no clothes and everyone will respect that.
So I'm slightly less optimistic, and I hope I'm wrong, right? That you know, for example, when you mentioned that if it doesn't pass, that it's going to be counterproductive, because I'm not sure if we can. Right now, we're mainly looking at the economic level, but to me, much of this seems to arise from almost like a higher order ideological level. Like if you look at the kind of incentive structures and the motivations behind the UN, for example. What I see there, and from, yeah, doesn't matter where from, but when you're interested in power and control, there's always kind of like, you know, why not get more? And to me, it seems that the whole economic layer is more of like a surface appearance where that appears, and these incentives to gain more control and basically regulate more for the sake of power, not actually necessarily to do the right thing, but to have more control over this situation is to me an underlying problem. So that's why I tend to lean in the direction of, you know, basically start with the use case of basically a sneaker net where we try to build something up, or we run around with USB sticks and see how we can make that work to have a certain kind of safeguard for that not to get too far. But maybe I'm too pessimistic on this. Maybe that's not necessary.
I don't know. I could hear more pessimism, I think.
I would like to stay with this, like just Vlad, your conversation with Andrea and Fabian and the comments in here. It would be interesting just to dive in, to stay on this almost, to keep working it out, just not to maybe go at it from other angles.
So, I mean, yeah, can you give us a summary of what? Can you give us like a summary?
Yeah, that's nice of you, man. That's very nice. I'm gonna push back against that very nice thing and my impulse to do it. I'm wondering if one of the people who's been listening or talking has sort of like something on their mind that's staying on this conversation that you framed about, you know. Does anyone have any thought about this?
I just want to put on the table one of the things that maybe helps this conversation in a sense, because this is really the model DAO law, the Koala Coalition for Automated Legal Applications. A couple of people who are here know that very well, and so on. Doesn't matter. So the idea behind drafting a model law for DAOs was precisely to try and, on the one hand, provide regulators with something that they can make use of that seems reasonable, and on the other hand, try to provide for people who are building DAOs and working with DAOs a certain degree of security when it comes to questions of liability and if something goes bad. So what if whatever happens, we really don't know exactly how national regulators will be trying to grab onto people and assets. It's not clear who will be held liable for which kinds of things. And so I think that the idea with this model DAO law was really to try and bridge that gap in a way that is meaningful from the crypto space. I mean, it hasn't gone anywhere. It's being drafted, and we'll see what to do with it. But in a sense, I think that would be the only way forward, to bring in to invite the regulator to regulate in some way. I think there is no way that there will be no regulation. I mean, and I think that it's not I think it's a too exposed position for anyone developing stuff and building stuff not to know what can come down on you in
Sure.
any given moment.
But you don't need to agree with the regulators like how DAOs are incorporated in order to have that security at all. You know, I think this is like way overkill. Like, and especially because it's an international law question where this is never going to be resolved, and so you need to have language that's much more soft and much more loose, where you say, look, we're going to do things in accord with international law. We're not sure necessarily what that's going to look like. And we can't know upfront, you know, who is going to be liable in what circumstances and in what way that's going to take, what form that's going to take. You know, I think it's a much more secure posture to not need to agree on how things are going to play out in a national setting today, because this setting isn't a national setting, and there is limited or no authority to in crypto law to legislate. Or to have this kind of you know, like civil law posture. In my opinion, you know, crypto law is not a civil law tradition, and I don't think that it'll ever be. And the reason basically is because of partly because of the just international scale, but partly because it is itself a rebellion against legislation, against the international global financial system, and it's not going to. I just don't think it's going to be legitimate to try to have like a kind of a regulation in words in crypto law that's going to that people are going to agree to, presumably, for how these things play out in these various cases.
So no, but that's not, so the idea is much rather to go, so the idea is to go the other way around. The idea is to say, look, the way DAOs function already brings in a lot of the securities that you regulators are looking for. So you regulator are looking for incorporation. What we can tell you is that a DAO is in a smart contract on a blockchain, so it is in a sense incorporated in this way. You are looking for whatever kind of security. So the idea for this model dollar was to say, okay, what are the
giving the regulators
most,
but giving
what are the
regulators what they
most
want
basic,
isn't going to give us justice in crypto law. It's not going to give us a
but
good way
Vlad,
to
it's
deal with
not about
terrorism.
justice
It's
in
not going to be.
crypto law.
It's
It's
one of the
about
topics.
protecting people in crypto law who are working on all these things.
That's
who don't know
that's a
how,
minimal. That's a minimum concern.
how these
relatively
things.
speaking.
Yeah, but that's
if you think about the harms that could have happened because of crypto, it's orders of magnitude worse than everyone in crypto being thrown in jail. Like that would be okay relative to like how bad this could get, given the way that the governance in crypto law is set up right now. Like fully autonomous software can be way worse than developers going to jail, you know, in the context of like international terrorism and international crime, in the context of all sorts of different things that constitute international injustices that actually need to be addressed, and for which providing security for developers or regulators does very little.
Well, I think that it,
autonomous software, just a question, because I do want to have that clarified. Fully autonomous software, how far are we? Like, what's the level of technology readiness when we are talking about the autonomous
look, the tech is ready. It's just not scalable. I mean, but the point that I'm making with the fully autonomous software is about the legal norms that we have in crypto law, like the immutability, like don't change the software thing, isn't going to allow you to stop the the software, and like it doesn't matter, you know, what you legislate. Like there's other kinds of interventions that are necessary here.
Right, but we have cases that go against that. The DAO hack actually suggests that there is no immutability, and we also know that if there's going to be any time like. But
let me tell you, that's not the norm. That's the exception. And if
well, but
you tried,
confirms the rule. I mean, the fact that that actually happened once is enough for us to know that that can happen again.
I agree with you, but let me put it this way. I am extremely anxious about this, and not for no reason. It's not a given. It's not like you can take this for granted. There are many forces acting in this space. It's not, you can't really assume that can happen again. And the norms, the belief, the doctrine, the the thinking that people have is not set up to
All right.
allow a persistent, repetitive, normal kind of DAO hard fork situation. In fact, people are extremely resistant to it, and I know because I work hard all the time to work for exactly this, you know.
So one question would be in terms of scalability and adoption. The rates are still quite low, and the rates are low because basically people still don't know how to or don't have the ability to spend crypto in real case scenario. Like I still cannot really go out and buy a house, or it's really hard for me to, for example, buy a coffee with
Yeah,
crypto.
but you can't count on crypto sucking forever. I mean, I wish it would, and then I would have way less
No, I
anxiety in
can.
my
I
life.
actually can, because when it comes to how do I buy the real assets in real life, that is when, for example, the central bank or the state comes into the play. They can actually intervene when it comes to which stores are going to be adopting this type of technology
Okay,
and allowing
well, if you think that state law is going to keep you safe in
to some
crypto
extent,
law,
actually,
you know,
no, okay, I'm not saying that
you
it will
know,
keep me safe, but to some extent, it definitely has the intervening point. Like there is definitely a way to influence the market when we are talking about how state can do so. I cannot just rely
I
on
agree with
the
you,
whole.
but no state has the authority to dictate the number of bitcoins, you know, or to like change, or or to have a hard fork, or
For
to like
sure.
censor the transactions,
No, no, no. I'm not talking
that's a
about
real
that.
issue.
Sure, but I'm not talking about that. I'm actually talking about what happens when some Bitcoiner wants to transfer that into fiat, or what happens when they want to spend
Sure,
Bitcoin for real
but
assets.
but 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 you know, you are assuming that this like access to the financial system, that you know this, that the international financial order is, and their regulation of the global law is based on, is like much bigger and a much bigger part of the economy than it really is, and has much more force than it really does. And you're like you can't like rest like the fate of crypto law on global financial markets regulation or global payments
it kind of
regulation.
depend on that, yes.
I
But I
mean,
mean, to come back, Vlad, to your original example, if you had this, if you had for somehow, I mean, we would have to know how you know, but you know that there are transactions going on the Ethereum blockchain that come from human trafficking.
Yeah, let's just say human trafficking DAO, like it's a known human trafficking DAO. Let's say like there's like a you know, it's not just like a single address, it's like a multi-sig and an organization that has a decentralized structure. Like in one day when you have DAOs, decentralized organizations running a criminal enterprise to do
So
human
basically,
trafficking.
but then what you would know about them is, number one, what would you know? You would know their wallet addresses. Would you be in any way able, other than by background knowledge, know who these people are? Is there anything else than the wallet that you can know?
Well, I mean, I would insist that there is international investigation and all the traditional, you know, infiltration, monitoring, everything. I mean, well, like this is like a full international law kind of like Interpol kind of situation. You know, there's no, you know,
No, I really don't
there's
know
no
how
angle.
Interpol works, but but I mean, then so the idea, the question would be, number one, is there a way on the blockchain to seize the assets, to just say, okay, we're gonna freeze those?
Often, yes, it
Because that's
depends.
what you can do, right? That would be the one
Often.
thing that could that the blockchain community, that the Ethereum community could do. But
So
to
crypto law can do more
investigate
than
these
just
people,
that. Crypto law can do more than just that, but
so what would you
definitely one of
think
the
they
things
could
it
do?
governs, one of the main things that like it is governance of the protocol definition, but you
Yeah.
can also imagine that what happens is when people interact with these things and are exposed to the incentives from them, that their behavior changes as a function. And so the thing about crypto law is that it has this kind of like, you know, imagine there's people working for a DAO, and those people are working in based on like some app on their phone that they downloaded or something, and their behavior could change as a function of like what happens in this smart contract. and there's like smart property and all sorts of stuff that people hook up to the blockchain. It's not just it ends up being, you know, a creeping thing if everyone kind of hooks things up to the blockchain and blockchain apps it.
So I think I'm still struggling to see. So if we really take this like today there is I don't know, on Aragon someone makes a human trafficking DAO, and it's there. What are the options of the Ethereum community to do something there? What could be done?
Yeah, I mean,
technically,
we could delete the DAO quite easily.
Yeah.
But this is, I mean, consensus based in a community of a crypto. I mean, the first question that I have is, how do we even decide that human trafficking is a crime? With human trafficking,
oh my God.
No. Okay, so let me repeat. The human trafficking is not so bad. But let's say it's an enforcement DAO.
Anya, I'm going to leave this call.
I mean, the crime is not really well defined on a global scale. We don't have consensuses when it comes to what.
That doesn't matter. You don't need to have a definition to know that something's wrong, you know, and to see that there are sanctions against it and that they're serious and that there's victims and that people have been, like, you know, dehumanized.
I strongly disagree, Vlad. How can you not have a definition of a crime and do the sanctions either way?
Because you don't need to have codes of law to do law. There's sometimes injustice is so great and it's just overwhelming. And there's like, you don't need to have, like, you know, sometimes like you don't need to define exactly the crime if that will like apply in all general cases. I mean,
Vlad, can I ask you something?
Just think about the difficulty of definitions in philosophy and then try to imagine in law how much more difficult it'll be.
Vlad, have you ever read the story of King Rex, by Lon Fuller? Have you ever come across this? Vlad, this is your story. So Lon Fuller is one of the big American legal philosophers of the 20th century, and he's very much into the idea that morality is in procedure and that procedure things have a moral standing. And a part of his book that he wrote is this really beautiful story about King Rex and the way he goes out to make law and how he tries to just do it very well. And each time he makes an attempt, something goes wrong. And so this is how then Lon Fuller develops these 8 principles of how law has to have morality. And I literally think, like, I love Lon Fuller. I think it's very interesting. And I think there's a lot of, it's really, he's a fantastic thinker. And I think that there's a lot of purchase to the idea of procedural matters and morality and law. And then I think that when Anya just challenged you and said, well, you cannot tell me that you just want to go out and do like sanctioning of people when there's not even a law. It's just a law that you think that lives there. I think this is really Lon Fuller 100%. I don't want to kill this conversation, but yeah, it's like a 15-page story. It's nothing.
There doesn't need to be a law for you to have grounds to sue someone. There doesn't need to be a law for you to have to be abused, for you to be victimized, for you to be
but you can, but law can be abusive. Like if you just say, I, Vlad, know that this is wrong, and I think it isn't because that's so law has to be publicized, law has to be known.
No, that's not true. That's not true. I mean, that's been, I mean, that's kind of like a myth, right? I mean, like the private law is very often not publicized, and rulings are very often not publicized in arbitration, and people have lots and lots of ways that they manage conflict outside of public systems. And the law is so complex, you can't insist that it should be following some principle, or that it should fit according to your definitions, or that you have to be a little more impartial, and like you can't like enforce your normative like hopes for a legal form that is inherently much simpler than the law. Even the publishing of a law changes the law. It's not like you can write down the law or like define criminality, or it's not like the correct analytical approach. It's because of the complexity involved in the phenomenon that we're talking about. I mean, like the definitions of terrorism are sloppy, like, and it doesn't stop, you know, counterterrorism stuff.
So we have 2-3 minutes left, and personally, to me at least, it feels like we're just like this. I mean, man, if we had another, like, it feels like we're just like getting somewhere. Do we have any feelings about how we want to sort of like end our summer trip? You know, how do we want to reflect or think about, you know, as we go back home?
We're totally unprepared in crypto law to take responsibility for stuff that's happening inside crypto law. I mean, that's a big, like, my takeaway. One of the main takeaways I have, like, so like the legal culture is not really available for us to deal with our own problems that we might cause down the line if the tech ever gets good.
Could we do that actually? What you just did, Vlad? Starting with you, if they want to take a chance to have one last, like, little statement to say goodbye, anything or any takeaway? That's really interesting, Vlad. I just hope to stay in contact with some folks, look forward to future conversations. Really enjoyed today's conversation and think like practical examples that we could build, you know, actual like model DAOs or bits or work through game theory stuff. I don't mean game theory, but, you know, like work through examples of this. Sounds really exciting to me. Always happy to have people reach out. I throw the hot potato to Andrea.
Thank you. No, yeah, I agree with all the things that it is very interesting. And I take away from this, and this is maybe addressed more to Vlad than to, but I think that was the dominant part of the conversation today, that my sense is that, and I hear this from you, Vlad, maybe I wrongly hear that, but that there is a sense in the crypto community of trying to reinvent the wheel when it comes to a legal system, to putting law into the game. And I think that this direction is the wrong direction. I don't think that you can reinvent, that you can come up with a just legal system if you just sit down and think a lot and then you come up with something great.
That's not what we're doing, right? But we're also not just going to inherit civil law. Like, there's so many legal traditions that have so many that are more appropriate for crypto law, like as a fit.
So I think that it's completely a pick and choose approach. I think it should totally be a pick and choose approach. It should be all the raisins from the cake. Everything that is useful is good. It doesn't matter what it tags onto. I just think that keeping in mind that what we call law, what we have come to call law, that we have come to accept as legal fundamental principles, as ideas that we associate with the idea of justice, are things that have grown over centuries and have grown through political struggle, have grown through many different things. So I think that this idea that you can just sit down and reason about it is something that I would caution against. So I don't know. I think this would be my message for the day. I think if in crypto law, we need to think about how to accommodate with the existing systems in a way that makes it doable and workable rather than to reinvent new things.
I mean, we're already dealing with new things. I mean, we don't have to invent anything to like have to like face how deviant crypto law is.
Andrea, who do you throw the hot potato?
Oh, sorry. I throw it to you, Anya. Perfect. Here you go.
Right. I actually very much enjoyed this. Maybe my taking will be that I hope that these types of calls are going to be taking place a bit more often. I kind of miss koalas a lot, and I do believe that there needs to be space created for legal discussions, and not just us waiting for 6 months or 1 year, or maybe till it's too late to have these sort of discussions with thinkers like yourself. Andrea, John, Morshed, Anuj, and Vlad, I mean, very much thank you for creating this space and leading us through the 5 days.
Thank you, Anya. Thank you, everybody in this
Thanks,
group.
everyone.
Anya, does anyone else want to
I'm
say
gonna
any last words?
I mean, yeah, sure.
We're out of time, aren't we? Almost.
Thank you, everyone. I really enjoyed this discussion on blockchain and cryptocurrency. I just want to make a little suggestion. I do notice that a lot of transaction of blockchain and cryptocurrency is done online, and a lot of people all over the world put their money into Bitcoin and cryptocurrency. What I would suggest is that, being that there are no state law presently, I do also know that in my country there are no law regulating the crypto and blockchain. But what I would suggest is this: maybe all these crypto companies can actually have a physical building in a country where they know that a lot of the citizens in that country are transacting in Bitcoin and blockchain. And if this is impossible, they can actually enter into agreements with companies that are on ground. Why I'm saying this is that most time if you invest in Bitcoin and everything goes wrong, it's also likely you're going to lose your money. I feel that somebody should be sued for that. And if everything is being done online, I don't really see chances of you see somebody online, somebody you've never seen. But if there is a physical building, or if there is a physical company that is linked to that a blockchain company, I think you can sue that physical company, which has a parent a company in the blockchain company. So these are the kind of things I'm actually looking at, because I know that a lot of people, and there are a lot of scam going on in my country with regards to blockchain and cryptocurrency. You just see it online, they tell you, invest so amount, you get double of so amount in 1 month. And after the investment, you end up losing everything. And you don't have anybody to sue because it's online. So I think there should be a kind of connection between online and a physical company on ground. That is just what I'm actually looking at. So that when you want to sue, you should be seeing who you want to sue. Thank you so much. Thank you.
Thanks for that, Abara. May I just ask, which country in Africa are you calling us from?
Okay, I'm in Nigeria, West Africa.
Thank you, thank you. Yeah, the idea of emphasis is really cool.
Yeah, it's
Australian.
This has been a very pleasant interaction, very pleasant encounter. Like, my main thought is like, how can we keep this going in what format? Like, I'm very open. I really agree that I believe we're quite a bit behind in many of these issues, and we cannot just rely on migrating what exists today. For me, some of the issues come up on ethics, very much like what Anya raised, of like, how do we establish something to be a problem or not a problem, and how can we basically have a general interface to have that dialogue. That's on one side, and then on the other side, how can we make things stable and safe. So, but anything that we can spin off from this to continue the dialogue, I would very much enjoy that.
Anybody else wants to add anything? All right, then I'll get my second coffee of the day. Thank you so much for joining. Yeah, please do tell us more what your experience looked like. I posted a link to our WhatsApp chat, which was created a few months ago, and it wasn't really used that much, but we might be reserving it for, sending out the links to these types of calls, and looking forward to have more discussions like this one.
But team.
Thank you. Bye.